Welcome to Devine Intervention, shedding light on Illinois property tax.
Hello and welcome to Devine Intervention, shedding light on Illinois property tax with Nora Devine. Nora has been a property tax attorney in private practice since 2005. She has developed a statewide practice in all jurisdictions in Illinois, and she represents all property classes. I am your host, Kevin Rosenquist, and today's episode is the ins and outs of agricultural land assessments in Illinois. Nora, welcome back.
Thank you.
So, how does Illinois assess agricultural land and farm buildings differently from other types of property? What factors influence the assessments?
Well, the land is complicated and multi-layered, but it's also kind of brainless for us and for the assessing officials, because essentially if the land does have an agricultural classification, then all the assessor has to do is say, yes, it qualifies for agricultural. No, it doesn't. That's it.
Mm.
And then from there, if it does qualify for agricultural preferential assessment, then the assessing function then goes to the Illinois Department of Revenue, which in connection with FATAB, which is basically our Farm Bureau, they're the ones who decide what the productivity of the soil is, and they're the ones that decide how the land should be assessed. So the land in northern Illinois is considered to be much more productive, or has proven to be much more productive scientifically than the land in the southern part of the state. So that's why you see different productivity values for acreage in the northern part versus the southern part based on productivity. And cultivation is not the only way you can get agricultural classification. You can also do it by fencing the property in and allowing the property to be used for grazing. And also any kind of dairy use, any kind of bee use, any kind of mushroom growing. There's a lot of different things you can do in order to qualify for agricultural classification. And the one thing under the statute is that it does have to be used consistently for an agricultural purpose for more than 2 years before it can qualify for this treatment.
Okay. And are there specific eligibility requirements for farm buildings?
So the buildings are complicated in my mind, because when the statute was written, it said, that the building should be assessed pursuant to its contributory value toward the farm enterprise or some such. The language is something like that. And
Okay.
what does that mean?
I
I don't know, and I think what it meant back then may be different from what it means now, because there's been so much consolidation in the farming industry.
Right.
You used to have a lot of farm families and family-owned farms, and now a lot of it is really consolidated in a certain number of large corporate operators. So yeah, I struggle with this question sometimes when I'm representing farm buildings. I represent grain elevators, and I represent complicated properties that are agricultural, but what are they worth? And then when you think about the way that people grow the marijuana, I think we have yet to see how the Property Tax Appeal Board or how the courts are going to treat some of those buildings, because they're really more like industrial buildings. They're kind of, you're growing the stuff inside. And that's a little
agriculture,
different.
right?
Yeah. I mean, So I think some lawyer, maybe me, I don't know. I don't have any cannabis clients right now, but some lawyer probably will advance that argument that the building is worth whatever it's worth to the farming enterprise. And, to the extent that the licensure is really where you're gaining your value and not your buildings, I don't know. There could be an argument to be made there. So right now, the statute says that you're supposed to assess it pursuant to what it's worth to the farming enterprise. What that means, well, people of goodwill argue all the time about what that means. And there's even a 2-day class for the assessors that is put on by the Illinois Property Assessment Institute. And they literally go on a field trip the second day. They all wear, jeans and boots, and teacher takes them on a bus out to a nearby farm near the class and shows them how to value farm buildings. And, it begins with knowing how big they are. And then you go to some software and you figure out what would it cost to build this structure new today. And then from there, you have to figure out what's the depreciation, what's the real value of this building to the farming enterprise. And even the most broken down farm building that you see on the side of the road when you're driving through the state of Illinois, there's still getting some use out of it, I guarantee. Even if it, there's holes in the roof and everything else, I guarantee you, if you go in there, they're using it for something.
There's
So,
something, yeah.
you do see some assessing officials that are willing to depreciate a farm building all the way down to zero. I have seen it, but usually they don't go all the way down to zero, even if it's like almost falling over. So, um, so it really depends.
Well, what about soil quality, land usage, zoning play? Do all these things play into the assessment process?
Well, with the urban sprawl, it became difficult for people to hang on to their acreage. The value per acre for development purposes became so high that a lot of farmers said, "Okay, I'm out," and they sold. So this is a different way of assessing property that does incentivize the farmers to stay put, even though the value of their acreage may exceed the production value of the property.
Mm-hmm. And I mean, I don't remember, but back in when I was living in Illinois, the soil quality was not the best, because they take all the good soil and sell it for topsoil. So like, I don't know. I just remember it being
Oh,
kind
I
of
don't
an
know.
issue.
I don't know. So I bet these farmers are not doing that. I don't know. I
Yeah.
bet they want to hang on to it.
Yeah.
But I've always dreamt about going into like a full blown property tax appeal board hearing with a bucket of dirt, and spreading it out on the table and saying, "Look, it's not productive." I mean, how do you even know about these things? So essentially, you can't really, once it has agricultural classification, there's nothing really you can do after that point to quibble with the property tax bill. So,
Yeah.
it's like if it has agricultural classification, then you're being treated pretty well. If you want to argue about, hey, this soil is not quite as productive as the soil map says it is, then you'd have to order a very expensive study to be done on your acreage. And you better have a whole lot of acreage to justify that kind of expense. And there better be a whole lot of money at issue, but there really probably won't be because
Right.
the tax bills on these properties are so low.
Boy, if phones were allowed, you could have a viral moment there pouring dirt onto the table in an appeals court.
Well, I don't think anyone's done it. I'm not sure. But as for the buildings, with grain elevators, it has become, what is their capacity? So, how much corn can they dry out? How much soybeans can they dry out? How much can they process? So they go almost to like a per bushel type of a assessment model to see how much can this facility process in a season or in a year, and then they take those numbers and they extrapolate and assess value based on that.
How do agricultural exemptions or special use assessments affect property taxes for farm buildings?
It's important to avoid using the word exemption because exemption has a specific meaning. Exemption means that it's exempt from property tax, and that would be like your hospitals, your churches, your educational use buildings, your property that's owned by units of government. This is a preferential assessment. And if the parcel is small and the assessed value is less than 150, then there are certain counties that won't even issue a tax bill for those parcels. But that doesn't make them exempt. They still have an assessed value. It's just that the nuts and bolts and the mechanics of sending the tax bills out is that some counties won't send one out. So it is a preferential assessment rather than an exemption. And what happens is it drives the property tax contribution down for all of those properties that have the preferential assessment. And then what happens is the taxes that are being requested by the units of government, such as the school districts and the municipality and the county and so forth, those tax dollars are coming from the other properties in the jurisdiction that don't have the preferential assessment. So it's a shifting of the tax burden from the farm properties, to everybody else, essentially is what it is.
What are some of the common mistakes you see farm owners make when applying for agricultural assessments?
I mean, sometimes they make the mistake of thinking that it really will be like 2 years to the day before they can be considered agricultural. Some assessors will, consider implementing the classification earlier depending on the facts. That's one thing on the front end with the application side that I've seen. And then with the year to year maintaining the preferential assessment classification, I have seen issues where the owner of the land has hired a farmer, and the farmer, they're either paying the farmer or the farmer's paying them. So either the farmer is renting the acres from them or they are paying the farmer to plant it, depending on the situation. Usually it's the farmer is renting the acres from them. But if there's 1 year where there is not enough yield on a certain portion of the property, the farmer may not plant and harvest those acres. And an assessor who's paying attention, and the closer you are to the city of Chicago, the more they're paying attention because the fewer farm parcels they have. And they're
True.
really looking to see, is this parcel really being farmed? It's the minute they see that it's not being farmed, they yank that preferential assessment classification, and the tax bill can really skyrocket. So we, in our letter to all of our clients who do own land that has agricultural preferential assessment, we tell them in the strongest language possible that if they have a contract with a farmer, they need to make sure that farmer is aware that if they do not plant and harvest as planned, they will be responsible for the resulting property tax increase. And that has really ignited some important conversations between the landowner and the farmer who's supposed to be doing the cultivation.
What challenges are there for property owners, for agricultural property owners, when it comes to appealing an assessment?
If you are supposed to have farm class and you don't, and the assessor won't give it to you, you can appeal to the Board of Review. And I've had to do this before. I had a friend who owned a horse farm up in Lake County, and he bought like a 5-acre parcel that was adjacent to his existing land, adjacent to the north. And he owned this land for several years, and he was using it as pasture land for his horses. And he had a horsing enterprise there. It was not a hobby. And he was paying like $20,000 a year in taxes on this land. And so I used to bring my little girls up to that farm to visit the horses, long ago when they were actually little. Now they're all larger than me. But, and one day he said, I don't know why the taxes over there are so high. So I looked into it for him and went to a hearing at the Board of Review, and I didn't have any proof as to when he built the fence. And so I asked him, I'm like, well, do you have any receipts? No, my farmhand did it. Okay, well, can he come to the hearing? No. Okay, well, can he sign an affidavit? No. And I'm thinking, well, they're really going to want to know that there was 2 years of continuous agricultural use here, or they're not going to change this classification.
Right.
And I don't really know what I'm going to do here. So one night I got the bright idea in my head to use the photos that I took of my daughters in front of the fence post. So the horizontal pieces of the fence were plastic, but
Okay.
the upright posts were actually wood. And so I had a picture of my little kids sitting in front of this fence, and I blew it up to like an 11x17, and I took it to the hearing with me. And I'm like, look how old this upright post is. And it was all I had. I didn't have any receipts. I didn't have an affidavit. I didn't have a witness. Yeah, I couldn't get anything. So, and then so one Board of Review member's like, yeah, that upright's old. And I agree, we should do it. And the other one was like, well, I'm not going to do it. There's no proof. There's no receipts. There's no contractor. There's no, no permit. And this is in a rural area, so there wouldn't be a permit for a fence like this.
Right.
And then finally, the third Board of Review member, and this is the most important thing that's ever said at a hearing ever, said, well, I was there and I drive by there all the time on my way to thus and so. And, I know that fence has been there for at least 2 years. And then with that, I had the 2 out of 3.
Wow, that's fortunate
to make the change. And it is a big change because, that brought his tax liability down to less than $500 from $20,000 or so. And if I remember right, I might not remember right, but I think that's
still, even if it's close to that, that's incredible.
Well, and that's forever. And that's forever, and there's no look back. So when it stops being used for farmland, it's not like they have a 3-year look back where they charge you the difference or anything like that. It's just, it's a great benefit if you can apply for it, and if your facts match the statutory requirements.
Wow, that's crazy. That's a big difference. 20 grand to 500. Holy cow. Is this something when a farmer wants to, or a farm owner wants to apply for this, is it something that someone should have legal counsel for? Is it something they should do on their own?
No, not really. I mean,
No? Okay.
we don't really even have a way to charge people for that. They tell us we think we want farm, and we say, okay, well, when did you start using it? And we give them pointers on, how to best show that they've had the 2 years of use and so forth. And then usually they can have the assessor out for a site visit, and the assessor can start tracking it as of the date that the agricultural use started, and then implement the correct preferential assessment classification once the 2 years has passed. we run into trouble sometimes because there's a question of when it started and the client didn't call until it had already been going on for a few years. And so like the hearing that I told you about, that's when you would definitely need a lawyer because, well, I guess he could have done it himself, but he was, he was elsewhere. I think he was at his other home in Arizona at the time. So yeah, he did need someone to pursue that for him. Yeah. And then, if you put bees on your property and the assessor doesn't think that's enough, then yeah, you might need a lawyer to go to the board of review, and they might not agree that it's enough as well. And then you might have to go to the property tax appeal board and see if you have enough facts and enough evidence to get them to agree that you've done enough.
You can see that guy's like, I don't even want bees. I just did this. You guys aren't going to let me. You're not going to give me the assessment. Come on now.
Well, some people really do get the pollination crisis. So
Oh
some
yeah,
people
of
really
course.
do
So it's a
want
big
bees.
deal.
You can get bees that don't sting. You don't have to get the ones with stingers.
Yeah, no, yeah, the bumblebees, the ones that the good bees are not really aggressive either. So, but that's not we're not going to do a whole episode on bees.
Well, I mean, maybe I'll pull all the bee cases. I know there are some. I'll pull them, read them, and share them with the viewers sometime.
I like it. Let's do it. All right, I changed my mind. We're doing a bee episode. Love it. So at what point do you typically get involved in these situations? Do you help people if they've been denied?
I give them a little advice up front, and then
Okay.
hopefully I don't hear from them again. And
Yeah.
then, if I do hear from them again, then I can see if it makes sense for me to get involved. So yeah, I mean, it's a shame to have to get involved when it seems like it's an up or down issue. Do I qualify or don't I?
Right.
But yeah, we have gotten involved for agricultural classification issues. And then with the farm buildings, with the grain elevators, you usually do need counsel because usually these major grain elevators are located in a jurisdiction where there's not a lot of commercial tax base, and the assessing official is trying to keep the assessment as high as possible. And what is this worth to the farming enterprise is one legal question that has to be answered in the course of appealing an improvement like that. And then also, what would somebody pay for it if it were available for sale? And all of the farm sales are really hard to understand. They're kind of convoluted because there has been so much consolidation in the farming industry. Sometimes they buy something just so that someone else can't use it. Mm-hmm. And so that's not really a market sale. There's games going on there. So, mm-hmm. And so if there's something like that underlying all of the major farm sales right now of grain elevators and so forth, then it becomes pretty easy to argue with the other side about how best to peel back the onion and understand the value for property tax purposes.
Mm-hmm. Absolutely. All right. Well, thank you for joining us on Devine Intervention, shedding light on Illinois property tax with Nora Devine. To connect with Nora and the team, visit thedevinelawgroup.com. And please be sure to like and subscribe to our channel. Nora, thanks so much for your time. It's a really interesting topic. I appreciate the chat.
Thank you. See you again soon.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.